The sitting is resumed.
Order number 12, sir. In the name of the Honourable Leader of the Senate, to move the second reading of the Criminal Proceedings Witness Anonymity Bill 2025.
Senator Cummings.
Thank you very much, Mr. President. Mr. President, we spent the entire day today speaking about the issues that are confronting the country with regard to crime. We've spoken about and talked about, Mr. President, the challenges that our people, our public, our nation have been facing as it relates to safety, crime, and security. Mr. President, we have heard in the public domain on more than one occasion about the call for the police service to do something about crime. We've also seen the speed with which oftentimes the police are able to identify and apprehend perpetrators of crime. I want to pause for a moment, Mr. President, and say here in this moment that despite the many challenges that we can see with our own two eyes, insufficient numbers of Barbadians joining the Barbados Police Service, insufficient support over many years and now investment in the Barbados Police Service over more recent years, that despite the challenges that they have been facing, Mr. President, the police in Barbados have an extraordinarily high rate of apprehending criminals. There is no question about that for the most part, Mr. President. However, the challenges that the police service relate to what happens once they have identified who is involved in a crime. Now, Mr. President, I went to university in Jamaica. I did undergraduate studies in Jamaica, I should say. I lived in Jamaica as a student, and then I lived in Jamaica working for a few years. So in both incarnations, Mr. President, I know what it is in dance hall culture to talk about snitches. I know what it is in dance hall culture to talk about informer fided. I know what it is, Mr. President, and many of us have watched that Being a Man movie from a long time ago with a song that has been publicized over many years, Mr. President, Walk and Live, Talk and Punctuated Dead. We know that, Mr. President. I punctuated it, yes. So we've lived that culture and seen that culture in other jurisdictions. But I think that Barbadians over many years have often felt that happens elsewhere. What we are seeing now is that there is a brand of criminal in this country that has imported by their relationships practices that we have seen happening in other jurisdictions for a long time into Barbados. We talk in economic terms, in financial terms, in global business terms about the globalization of business, the access to technology and how things move from one country to another. And let us be in no doubt, Mr. President, that based on what the public of Barbados is seeing, the criminal element has also been attempting to cross borders. And they are partnering with parties in other jurisdictions that practice cultures and practices that are foreign to this nation. And they have engaged in practices that have resulted in the intimidation of witnesses when the police have identified them as the culprits involved in a crime, and they have begun to threaten witnesses or to threaten their families. And what has happened, Mr. President, and I speak in this forum, Mr. President, about a recent, I don't even know if it's so recent anymore, it was 7 months ago, we had a very public shooting incident in a community, and the community was speaking about the subsequent lockdown of that community by the police as they sought to undertake an operation. And I remember, Mr. President, one individual speaking in the public newspaper, a gentleman, and he said this, he said, "We may live in fear, but we are not giving up the bad men, because tomorrow they will be on our doorsteps." That's what they related to the newspaper, and the newspaper carried it for public consumption. The police have indicated on more than one occasion what has been happening. There is a case, Mr. President, that I have been following or had been following in the past with a young man, a popular young man who sang and acted and so on, who was gunned down. And miraculously, in a place populated with lots of people who previously thought they saw and said that they saw, when the case is called and they're called as witnesses, Mr. President, they suddenly saw nothing. They don't remember. They can't be sure what they said they saw is actually what they saw. And a lot of that, Mr. President, is because of witness intimidation. The culture of intimidating people who have seen something and want to say something to protect our society and our community at the minute level. This legislation that is before this honorable chamber, Mr. President, is to address that. It is to ensure that persons who fear for their own personal safety can safely give evidence in trial and that they have the protection of the system. What we are seeing, Mr. President, must be condemned roundly as foreign to this country. We are seeing serious crimes. We're seeing them being perpetuated by a group of people, Mr. President. They look as though they have barely lost their mother's features in many instances, but there is also, and one of our members in this honorable chamber spoke about, the use or the relationship between drug use and the type of criminal activity that we are seeing. I don't know, when we grew up in Barbados, we used to talk about bad drugs. You want some kind of bad weed. Now, I don't even know what it is that they're mixing in with what they're taking, but it is leading to what we have heard from the National Council on Substance Abuse to be behavior-altering activity with these individuals, causing them to be emboldened, causing them to be fearless, causing them to do things that under normal circumstances, when they come down from whence they were, they don't even remember in some instances what they have done. And so the relationship between the illegal drug trade and the kind of crimes that we are seeing is being exacerbated, Mr. President, in the commission, in this space in crime. We saw, Mr. President, in 2019 in Sheraton Mall, many people go into Sheraton Mall on any given day, whether it's to the food court, whether it's to go to shop in the hardware store or to buy clothing or something like this. Who would imagine that in broad daylight, in the middle of the day, that you would see what you saw in Sheraton? But that's 2019. Since then, what happened in Eagle Hall in ZR at a bus stop? Since then, what happened just below Well Gap in broad daylight? Since then, what happened across the way in Nelson Street, also in broad daylight? All across Barbados, there is the criminal element which has been emboldened, and they are stopping people from coming forward to testify. But there's another element of that, Mr. President, street justice. They're not engaging in the criminal justice system and looking for police to arrest nobody. As far as they're concerned, they are taking it into their own hands. They're doing what they have to do. And so we see retribution killings playing out and people living in fear in their own homes, in their own communities. So this legislation, Mr. President, and I want to go through the legislation, it has a number of sections that I want to speak to. It has in total 29 sections, and then it has a schedule which outlines the specific forms. In part 2, it outlines what witness anonymity refers to. It speaks about how it is meant to be applied. It speaks about maintaining the privacy of witnesses, and this has included, Mr. President, the measures that are contemplated in this, for example, by permitting evidence to be given by means of technology such as live link, which would allow for the virtual presence of the witness before the court, the parties to the proceedings to hear, examine, or cross-examine the witness if the witness is outside of Barbados, potentially for their own protection, the exclusion from the court of the defendant, especially in circumstances where it is as I have just described, to have the name, address, contact details, and other identifying measures undisclosed during the trial, and the witness is permitted to use a different name. Now, there are those who will speak on the legal aspect of this and what this means in terms of the right to be able to confront your accuser. but I will leave that for the legal team. You also are seeing in this legislation, Mr. President, the voice of the witness being allowed to be modulated so that it cannot be identified. We have seen in many instances persons speaking on TV, speaking in the news, and they are relating what they have seen or experienced, but their voices are modulated because they don't even want to be seen. They don't want to be shown on camera. They don't want their voices to be recognized because they live in fear. There are any other number of measures that this type of legislation contemplates that would ensure the anonymity of the witness. The measures that we're talking about are cost-effective, yes, but are meant to be effective in screening the witness and protecting them, their identity, and that of their families in some instances from identification by their accuser, and who may also be their threatener. In Part 3, there are a number of directions which are listed, and it covers clauses 13 through 27. And in this section, it talks about what kinds of aids to communication can be included, a warning to jury on special measures direction, and we can go into that a little bit. What happens, as I just mentioned, when you give evidence from on the outside of Barbados, direction prohibiting the defendant from cross-examining particular witnesses, also under the conditions defense representation for the purposes of cross-examination, and included, as I mentioned before, evidence by live link and evidence in private. So I've spoken about these measures before, and I'm connecting them specifically with Part 3, clauses 13 through 27 of the legislation. There are a number of regulations at Clause 28 in the draft of the legislation, and then at the schedule where you will see the various forms that are meant to be used, and there are a number of forms that give rise to the operation of this legislation. They include the following: the criminal procedures, the application for witness anonymity order, that is at the schedule. You also have here the witness anonymity order itself. You have the application to discharge a witness anonymity order. You have the application for special measures direction. And then finally, Mr. President, you have, or almost finally, the application for direction prohibiting defendant from cross-examining a particular witness. And then now finally, you have the application for a discharge direction. This is the matter before the Honourable the Senate. I don't think that any of us have been in any doubt about what we are seeing and dealing with. The criminal that we are seeing in Barbados today is not the criminal of 2001. They're not the criminal of the 1990s, not the criminal of the 1980s. They are a different beast. And I think I remember in a previous debate, Mr. President, speaking about a young man, I spoke about this, a young man who, in the court pages of the newspaper, the Nation newspaper, was accused along with an older man of robbing a woman who was on her way to work, taking her bag, her purse, and her money, robbing her, and getting away with her personal belongings. He was caught. He was apprehended by the police. But he had no remorse, Mr. President, none at all. She was brave enough to go forward and to identify who had attacked her. Both instances, in both cases, who she felt had attacked her. But this young man, 18 years old, is what caught my attention in the newspaper. He was just 18. And he said he was home sleeping. This older man came by his house and got him and was taking him to pick cotton because he was unemployed. And he decided that he's a different breed, and so he gonna rob the first person that he came across. He robbed the first person he came across, according to his own admission, bought some food, bought some weed, went home, ate the food, had a smoke, and went to sleep and rested himself. And when the police came and found him, he told the police, yeah, I do it. There was no issue there. It's a different type of criminal that feels emboldened. And if they feel emboldened enough to admit it when they do, they have also been feeling emboldened in the most critical cases, in more serious instances, to threaten people who they believe will cause them to be apprehended. That is what this legislation is about, protecting, in this case, witnesses who have the ability to lead the police to apprehending the criminal element affecting our society. And with these Few words, Mr. President. I commend this bill on witness anonymity to this honorable chamber, and I beg to move that it be read a second time.
Thank you, Senator Cummins. Senator Honourable.
Mr. President, a very brief intervention in this, with regard to this bill. It is, well, I guess it's with some regret that we have come to this stage in our life in Barbados, because many of us, you know, we long for those days where we have that peaceful Barbados again. We cannot bring any argument to say that this is not necessary. The only thing that we can possibly say is that at some point in time, we will need to go a little bit further in terms of the parameters for the witness protection. And that is unfortunate. And I'm hoping that we will recognize that crime has a cost on the state. Because in order to put these measures in place, there's a cost immediately for government to put the facilities in place. And we really need to take serious consideration, because oftentimes we hear that the softer measures may be a bit too expensive, but you also have to consider the money that you have to put out front in order to reduce the impact of crime, and here in this situation to allow cases to go forward where you've made a conviction, and to protect the witnesses to allow cases to go forward. We know in Barbados that we've had situations where potential witnesses may have been gunned down. So these are things that we have to consider at this stage. And even though with this legislation put in place, I'm seeing it working within the magistrate's court. And we've talked for a long time in terms of allowing evidence to be given in camera, which the attorneys can talk about the difficulty that you had in terms of putting these things in place. All I'm saying is that to fight crime, there is a cost. Why not spend the money up front in terms of reducing the amount of persons who unfortunately take that line and that direction? And we will support this legislation, but we do think that at some point in time, we will probably have to go much further with this and look at something from a regional perspective in order to be able to protect witnesses and have them available, that they will be able to come back to the jurisdiction when necessary to give evidence in especially large cases. With those few words, I support the bill, Mr. President.
Thank you very much, Senator Barrow. Senator Tate.
Thank you, Mr. President. I just have queries. I don't have a difficulty with the bill in principle, but there are some things that I believe could be clearer. While I'm looking at the bill, sir, I'm looking specifically at Clause 4, where it speaks to common law rules, and it says the common law rules relating to the power of a court to make an order for securing that the identity of a witness in criminal proceedings is withheld from the defendant or on a defense application from other defendants are abolished. I find this vague, and it needs to probably be written a little better for the person who's not a lawyer. This will not make sense to the average person, but this is a piece of legislation that the average person needs to understand, because it is by understanding this that they will agree to be a witness. So I would think that this Clause 4 needs to be looked at. Clause 5, my query goes as it relates to content. At Clause 5, subclause 1, it says that the prosecutor or defendant may, in criminal proceedings, make an application to the court for a witness anonymity order in the form set out as Form 1 in the schedule. Subclause 2 says where an application is made by the prosecutor shall, unless the court directs otherwise, inform the court of the identity of the witness, but is not required to disclose in connection with the application the identity of the witness or any information that might enable the witness to be identified in any other party to the proceedings, to any other party to the proceedings or the other party's legal representative. And similarly, subclause 3 and 4 has similar language. My concern is when one looks at Form 1, which is, sir, on page 28 of the bill, type of application, when one looks at the definition of court in clause 2, court means the magistrate's court, the high court, or the court of appeal. That would be on page 6, just for your information, Mr. President. So this application form 1 is an application for the order. It sets out how it's supposed to be done as it relates to making the application for the order. My concern with this is really on page 29, which actually says, in order to protect the safety of the witness, and then it says in brackets their name of witness. So how are we protecting the witness if we're putting the name of the witness in an environment where that document, if it is going into a court, will be seen by court staff? And on, well, I hope it's not happening. I hope this is not, and there you go. So Senator Boyce is there telling me it might air online, because we do have online law now. This needs to be looked at, because you're kind of shooting yourself in the foot. To me, the thing is, the order in its form 2 will again, it has here the name of the witness. So you're making provision for the name of the witness to be withheld, but you're putting the name of the witness if you're to follow this document. I don't think that could possibly be the intention of the persons who have drafted this bill, but you know, if it did, I can see it. So the order makes provision for, I'm sorry, the format for the order is form 2 on page 30, and it is saying basically, whereas I'm satisfied by an application of name of prosecutor or defendant, that in order to protect the safety of the witness, Monty, they were gonna kill me? I did. But yet, what I don't understand is that there is provision for a witness to use a pseudonym. There's provision for a witness to not to be asked questions that might lead to the identification of the witness. So there's provision. So you have the components, but you're still identifying the witness. There's something very wrong. This needs to be reviewed with respect to ensure that this bill makes sense. I'm not sure if the government is still going to move to have it passed. I don't know how they do things, but this really needs to be looked at, because if not, this is going to be a bill that is a paper order that nobody's going to want to participate in. I certainly would have a challenge in its current form advising a client on how to proceed as one who's looking for protection. So you're going to go to the extent of modulating the person's voice and doing all these things, but yet you're putting a witness name. I think this needs to be, what's the word I'm looking for? Sorted, it's expanded. Something has to happen, but in its current form, and it's very important that the government looks at this, because the form is how it has to be done. If this is part of the legislation, it has to take this format to be valid. So both the form for the application, the form 2 for the order, there's too much provision for the name. So in that regard, sir, I would say that this needs to go back to the drawing board for clarity or for amendment, for fixing, for real protection of the witness. If you look at, sir, when you look at, sorry? Oh, Form 4, what are you telling me about Form 4? So when you look at Clause 6, I'm sorry, sir. Yeah, but this one has, for Form 4, not only makes provision for the name of the witness, you get a date of birth. So you're getting even more specifics on how to identify the witness. Could we not do these things?
Maybe you haven't seen.
You see, the concept of anonymity and a witness protection and all that is not bad. It's a good thing, and you need it for people to give evidence. But then you can't you shouldn't, because you have brought it. You shouldn't be bringing legislation that speaks to the name of the witness. If this is passed and goes into circulation, it's going to cause a furore. So I respectfully suggest that the government relooks this bill, because it really needs to be something that you can use. But in its current form, unless somebody could show me something different, it is not gonna work. I certainly wasn't coming forward as a witness. I mean, if you want to put QT, and even if you put QT so they can still know it's me, you understand? No, we gotta do better. Sir, clause 6 suggests though that, and that's the thing, there's a lot of, the calls are not connecting, because clause 6 says, when making a witness anonymity order, the court shall take measures for the purpose of ensuring, and the court shall, so it has to be done, that the name, address, contact information, and other identifying details of the witness may be withheld and removed from materials disclosed to any party of the proceedings. Witness may use a pseudonym. Witness does not ask questions of any specified description that might lead to the identification of the witness. Witness is screened to a specified extent, and voice of the witness is subjected to modulation to any specified extent. You have the guidelines for the order. Your forms are flawed. I suggest that the government goes back to the drawing board with respect. I'm obliged to you, sir.
Thank you very much, Senator Day. Any other speakers? Senator Cummings.
Mr. President, I beg to move the suspension of this sitting of the Senate for 15 minutes.
The question is that this sitting be suspended until 7:50 p.m. today. Those honorable senators in favor, please say aye. Those against, please say no. The next, the ayes have it. Sit is suspended for 15 minutes, resuming at 7:50 p.m.